Today we will see about Pmla, that is Preventive Money Laundering Act 2002, that will be useful for IPO examination, PS Group B examination, and we will also see its amendments and important rulings in it, and full concept of Pmla you will learn today. And in this video you will also learn what is black money, what is hawala, what is tax haven countries, what are those tax haven countries, what is money laundering, what is grey list, blacklist, what is that financial action task force, and all these things. Let us concentrate on the concept. You might have heard about black money and hawala and money laundering. All these terms are always heard about it. You might have heard about it. And money laundering is the process of making amounts of money generated by the criminal activities such as drug trafficking or terrorist funding appear to have come from a legitimate source. That means this money laundering is the process of making money from criminal activity, but it appears to be a legitimate source. That is called money laundering. And the criminal activities may include like illegal arms sales, smuggling, drug trafficking, and prostitution rings, insider trading, bribery, and computer fraud schemes that produce large profits, and thereby it creates the incentive for the money launderers to legitimate the illegal gotten gains through money laundering. And the money generated is called dirty money, and the money laundering is the process of conversion of dirty money to make it appear as a legitimate money. So this is about money laundering actually, and I will tell you with examples also. Stay tuned. This money laundering generally refers to washing of proceeds or profit generated from drug trafficking, smuggling, terrorists, bribery, corruption, gambling, robbery, cheating, counterfeiting, and extortion. These are all the criminal activities that this money is earned through. And some of these common methods of money laundering are bulk cash smuggling, cash incentive businesses. I will tell you one by one what are these things also. Trade based laundering, shell companies and trust, this is most famous, and round tripping, bank capture. Round tripping is for round tripping, the best example is Sachem case. And gambling, real estate, black salaries, fictional loans, hawala, this also I will explain, and false invoicing. So money laundering has three stages, that is, one is the placement, layering, and integration. And the placement, what happens is that accumulating the money from illegal activities. I will explain clearly what is money laundering in detail also. And placement means you will accumulate the money from illegal activities, that is called placement. And layering means placing the money into financial system, that you cannot keep it with you. The amount will be have to be put into the financial system, and there it will be integrated by transferring the amount to hide the origins of the funds. That means where you got the amount, that has to be hidden. So you will integrate into the financial system and returning the money from the money launderer to spend. So again you will get back the money to spend on your own. So this is the layering stage, placement, layering, and integration it is called. Now we will see in detail with examples what is money laundering. You might have heard what is black money, hawala, and money laundering also. To avoid money laundering, in India, government has introduced many laws, rules, and acts. And there are two important acts that have been institutionalized in the system. One is the main thing is the Preventive Money Laundering Act 2002, and there are certain amendments in 2012, 16, 19, and so on, that also we will see. And on top of it, there is one more international level forum, that is called Financial Action Task Force, FATF. It is an international task force actually, which will monitor the financial transactions that are going ahead in all the countries which are promoting terrorist activities or any tax evasion policies. Here we should understand that which has to be put. This FATF has put the Pakistan under grey list also, and India is asking for keeping the Pakistan under blacklist. What is blacklist, grey list, we will see later. And One by one we will see. First of the we will see what is black money. It is the money, it is not the money that is which is in black color, we all know it. The money on which you are not going to pay taxes, any taxes, it is called black money. That means the money color will be the same, but whenever you are not paying taxes on the money that you have earned to the government, then that is called black money. And in India you have to pay income tax if you are earning any salary or any amount which is beyond 7 lakhs as per the latest budget in 2023. Earlier it used to be 5 lakhs, you have to pay income tax. And whenever it is below 7 lakhs now, you need not pay any tax, that we know. And there is another element called GST for business owners beyond 20 lakhs, they have to pay GST also in addition to the income tax. And these are two different elements of taxes, and it depends on different slabs, we know. And suppose here there is another element of GST, income tax, and some gateway taxes for the banks also you pay. Some it comes to some 2%, depending on your salary. You may come to 30% slab, and depending on the goods you are supplying or receiving, purchasing, this comes to 18%. So it comes to some around 50% of what you earn you have to pay to the government. That is the point there. And there is another aspect is that suppose if you earn as an inspector or some postmaster, you are earning something as salary, and some other aspects also you have to pay 50% as a tax mostly. And it depends also, whatever you earn you give 50% to the government. And if a person is earning 1 crore, he has to pay as a 50% as tax to the government. And if that person is ill health, then the government will be helping a little in that aspect. And with that some agony will be there for the taxpayers also. That is the point where tax evasion thought process starts. And we will see, let us see about the calculation aspect with reference to the crorepati's. If a normal person who is paying 7 lakhs or 10 lakhs means he will pay the tax normally. But when it comes to persons who are earning in crores, suppose if they have earned 1 crore here, they have to pay some 50 lakhs as tax. So this 51 crore I have earned legitimately, and I have to pay this 50 lakhs as tax to the government. That will be the pain point for those who are earning more. So they try to evade the tax, and that is what the government has to take care of, those tax evading persons, and find out ways and means to get the tax back. So that is where this money laundering act has been put in place. And let us take that if a 100 crore person is there, he has to pay 50 crores. So with this tax only, the government will be going for roads development, and giving ration for 2 rupees as rice, and even they go for the vaccination free. These all things, development activities, that this happens, and tax will help the nation to develop and save the people also to some extent. So paying tax is important, and government has to get the tax from the people so that they can move forward. Here for example, if a hotel owner is there and he earns some 10 crores, he has to pay tax as 5 crores. And if he doesn't pay the tax, then the amount with him is called black money. So whenever he gets 10 crores, he has to pay some 5 crores as a tax. If he is not paying 5 crores as tax, instead of that he is paying only 1 crore, then that 4 crores is called black money, we know it. And to do this, to avoid this tax, then he will go for a tax evasion methods. And there are two ways in which they go for tax evasion methods. One is called money laundering, and the second one is the hawala bazaar. And here you can see that if he goes for 5 lakhs, if the person has for less than 5 lakhs, there will be no tax, we have seen. If a person is having goods less than 20 lakhs, there won't be GST also. And if they have more than some 7 lakhs we have income tax, more than 20 lakhs GST we have. And there's for crediting this tax or to show this income, you need a bank account, and where the entire amount will be shown in the bank account. Whenever you have a bank account, there you have a PAN card, there you have your Aadhaar, and everything is seen by the bank, and they will know from where you got the money and where this money goes to if you transfer it to someone else. So this is all possible in the banking system. So when the amount is 20 crores, the bank sees it through the system. When the amount is beyond a certain amount, say for example in post office or in a bank, I mean bank means here it includes post office also. Whenever the amount certain amount is less than 10 lakhs, that the transactions are said to be less risky, and whenever the amount is exceeding, transaction exceeds 10 lakhs, we call it as a high risk, and medium risk if it is less than between 5 to 10 lakhs, and it is less than 5 lakhs, it is low risk. Like that we segregate the risk profile of a account. And in such a case there are some, we have the CTR, cash transaction reports. Whenever the amount is beyond 10 lakhs, we send a CTR to the from the post office to divisional office, it goes on 3rd of the month, and from divisional office to circle office it goes on 5th of the month, and from circle office to the DDG PCO it goes on the 10th of the month. So this is the process that is involved whenever there is amount beyond 10 lakhs cash transactions in a post office or a bank for that matter. And there are also called suspicious transactions, STR they call, suspicious transaction report. These are the transactions when you have some suspicious transactions, means some counterfeit currency notes you have seen. In such a case, immediately the transaction should be reported similar to the case that we have told. But earlier it is for CTR it is monthly basis. On 1 month it will be sent like that on 3rd, 5th and 7th I have told. But here in suspicious transactions it should be immediately reported as and when such a transaction takes place. So whenever a person comes with a counterfeit note, it should be immediately reported to divisional office. Divisional office immediately reports to circle office. Circle office reports to DDG PCO, and DDG they will alert the vigilance system, and they will do the next course of action. Okay, and here you can see that there are certain countries. So for example, if it comes to Hawala, there are certain countries like British Virgin Islands, K Islands, Cayman Islands here, and some Switzerland, Netherlands. Here we have Switzerland, we have here Mauritius. Some of these countries they don't have any tax in their system. That means whenever you go and deposit in those countries, in those banks, they will never disclose the tax information to anyone. Such countries they are called tax haven countries. And here we will see that there is a how money laundering goes also with an example. Here there is one Arab Hawala. What is Hawala also we will see. There is one Arab Hawala agent is there. There is one person named Vijay Mallya or Vijay here, and he has some 10 crores with him, and he wants to send it to India, to a person called Abdul in India, for example. So at this point what Vijay has to do, he cannot deposit directly to Abdul in his bank account, because the bank will see what is the amount that it is coming, what is its source, and whenever the amount is beyond 10 lakhs there is a radar on the accounts transactions either in post office or bank. So what these persons will do is that to avoid tax, to run the black money, what they do is that this Vijay generally he will give it to the Arab Hawala agent who is in Arab. He will give in this 10 crores to this Arab Hawala agent, and this agent will have to send the amount to Abdul. That means his job is to send the 10 crores to Abdul. How he will send? He will send through the Indian Hawala agent here sitting in Mumbai, and this person will give this amount to him. How this happens, we have to see. First, this person is giving this amount to the Arab Hawala agent. Then what happens is that he cannot transfer this amount to the account of Abdul directly through bank account. That is not allowed, because that amount will be with the radar of India. What he will do is that he will speak to this person sitting in Mumbai. He will call him and say, you pay 10 lakhs to 10 crores to this Abdul. That means he will not give the money. The money is still with the Arab person only. But this Hawala agent, on listening to his words, he will pay 10 lakhs to Abdul. But how this Hawala agent will know Abdul? And to identify whether this Abdul is the correct person, right person to give this 10 crores, there will be a password that will be shared, password or some passcode they will share. This Hawala agent at Arab will share a passcode to Vijay, and this passcode he will share it to Abdul, and this agent also shares the passcode to this Hawala agent in Mumbai. So whenever he meets this Abdul, if he says the passcode only, he will share that 10 crores amount to him. So that whenever he calls it, this 10 crores he will pay. But still this money of 10 crores is with the money is with the Arab only. Then how this will go to the next system, we have to see. For that you should be knowing that now what is happening in this transaction. Here the money has not moved from, money has moved from here to here, and the money has moved from here to here. But this money, Hawala agent has to share it to him because he has given the money. So for that, here in this transaction, the government is not getting any tax because it is not done through the bank. There is a tax evasion, chori ho raha hai. And another aspect is that money may also go into the hands of terrorists also. In this case, this money may also go into the hands of terrorists also. Maybe this is a person, sometimes this can be a terrorist also. Terrorist activities also can go with such type of transactions. So to avoid such transactions, government has given this Money Laundering Act 2022 to provide for this thing. Here to send this 10 crores from Arab to India, they have to do money laundering. Here comes the word money laundering. This laundering means it is the word in money laundering. The laundering word is derived from the word laundry. Laundry means, we know that we will do it for a clothes. We will wash the clothes and we will do the next aspect that is called money, that is called laundering. And for money also you will launder. That means you will make the money black into white, and you will make the black money into white by avoiding tax. So money also you will launder, that is called money laundering. And black money which will be flown through the wrong route or evasive methods, and by way of robbery, indirectly robbing the tax money of the government, it will go from one hand to the another, and it is called black money. And the black money is converted into white money at a later stage through a process. That process is called money laundering. So how this money laundering goes in India, let us see. There will be here what happens is that here up to here we have seen it is the amount is still with Arab, then it has to go to Mumbai. Here if there is a in India, in Mumbai, if you can see here, and this is some Mauritius here, and this amount has to go here. There is some Arab country, Saudi Arabia here, and this person, what does this Hawala person, what does he do is that in India they will open some 3 shell companies. This Indian Hawala person, they will open 3 shell companies. Shell means it is in itna kuch nahi hai isme. That means there is nothing in the shell. That means a false companies will be opened. Just they will prepare the accounting procedures, simple accounting procedures, wrong accounting, false accounting procedures. They will do some paperwork, and they will open a companies, 3 or 4 companies. In that, there nothing will happen. It is actually not a company. Something will go there, and automatically this Saudi Arabian person, they will invest in this shell company 1, shell company 2, shell company 3, like that, some 5 crores, 4 crores, some 1 crore, or and he will also get this money from, not only from Vijay, some other people also. This money also will come to Saudi Arabia, to the Hawala agents. There, that will be from 5, 10, some 30 crores, like that, and altogether it may come up to 100 or 500 crores. This 500 crores, they will invest in the, through share market, in the shell companies as an investor. And this is called FDI. This is a foreign direct investment, it is called. There is no tax here. Important point is that there is no tax for foreign direct investments. So they will evade tax by investing there. And but whenever you invest something there, if there is a gain, you have to pay the profit, you have to pay the long term capital gains, and some other taxes also you have to you have to pay. But what they will do is, these are all shell companies, there is no business involved in it. What they will show, they will show one day that this company is in loss, and the entire company is in loss, and it will be closed. So then whenever there is a loss booking company, automatically no tax can be paid, and whatever amount that is invested in this will be taken by the person who is sitting there, that Abdul. So this is how these things will happen. And whenever the amount, the whatever amount that is invested in the shell companies, they will be shown as loss companies by some accounting statements. They will hire some CA or whatever it is, and there is no company at all. How there will be a loss? So that is all false information, like Satyam and all those things, they have done like that. Here, therefore, the amount, it will be transferred from Vijay to Abdul by opening some shell companies and investing there, showing that it is has been invested there and there is a loss. And totally, they are, what they are doing, they are showing it as loss, and there is no tax that they are paying to the government. So who is the loser here? The government is the loser in this transaction. This is called money laundering. And to avoid this money laundering, just this process, they are doing what they are doing. What is that? They are doing the evasion of tax, and this is called money laundering. And for FDI, there is no tax, we have seen, that is called a tax robbery. So there are many other ways also, other than the shell companies, to evade tax by money laundering. There are different ways of money laundering, but shell companies is the most popular one, most famous one that we all know, and this method is the most famous one that these people are using. But here we should understand that a shell company is also having a problem here. If an Indian government says, if the Indian government asks Saudi Arabia and asks which are all the companies that they are investing in India in these shell companies, and if this Saudi Arabia shares that information, automatically they will be caught. So to avoid this problem, we have seen already that there are some tax evasion countries like British Virgin Islands, Cayman Islands, Bermuda, Netherlands, Switzerland, Luxembourg. So these are all countries where these are called tax haven countries, as we have seen. Then these people, they will just, what they do, they will, for example, in this previous case, they will send it to Nepal, and in the Nepal, that the entire amount will be cashed, and then they will send it to Pakistan. They will open account in some other person, then it goes to Sudan, then it goes to Libya, then it goes to Switzerland. Like that, there will be a multiple traveling of this cash, and thereby what happens is that the government of India will not be able to trace the money where it has flown from one person to another person, because it has been converted into cash. And so they will not be able to identify, and thus there will be a total loss to the government. So this is how money laundering is done. And uh, and whenever these Swiss companies, they will not inform anyone what is the amount of transactions that is happening in their bank accounts. And for that purpose, what happens is that FATF is there. That forum will help the persons or the shell companies, those things they will detect. And they will provide for a gray list. Here the gray list means there are two things. Gray list means the list of the countries where the people, where white money will not go, because if the Pakistan is declared as grey list by FATF, already it has been declared. Whenever it is declared as grey list, naturally what happens is that white money people, that means fair business people, they won't go and do business in the Pakistan. And similarly, there is another aspect also to, if a country is listed in the grey list, even the loans will not also be given to the country for development activities by any big firm, or for example IMF or World Bank or Asian Development Bank. These things are there, that loans also they will give, but it comes difficult. That means at a slow process it will be given. It is not that easy to get loans from the those IMF and World Bank and EADB if they are in the grey list. And if suppose this Pakistan is put into blacklist, means then IMF, World Bank and ADB, they won't give the countries which are in the blacklist, they won't give any loan. From IMF, if it is for short term, they can get loan from IMF. If it is for prolonged years, say 10, 20 years, they can get loan from World Bank. And if you want to get for a loan from Asian Development Bank, there also you can get, but it will be difficult for the countries like Pakistan, if they are put into blacklist, to get loans from these big firms. Whenever they don't get loans, automatically their unemployment rate increases. Whenever the unemployment rate increases, there won't be factories. There won't. Whenever there is no loan, there won't be any development activities. There won't be any factories. There will be unemployment, and finally, with unemployment and everything, there will be a fall in the GDP. And whenever there will be a fall in the GDP, there will be a stock market crash, and it will have a cascading effect to the lives in the country, and so it affects to a larger extent. So this is all about money laundering in brief, that you have to understand. Here we have seen that money laundering cycle. We have seen the collection of dirty money. They will keep it here they will integrate into financial system. They then transfer on the bank account of some X company, or payment of Y in the false invoice to the company, and they will buy the real estates, luxury items and some other financial investments like that. So this is a cycle of money laundering. So government has brought in this PMLA, and the punishment also has been made strict, so that people will not tend to venture this aspect. So any person found guilty of money laundering, a rigorous imprisonment of 3 to 7 lakhs will be imposed, and a fine up to 5 lakhs will be imposed. But this has been revised later. This is as per 2002 Act, and this 5 lakhs has been revised, and this has been done away, and it has been told that it will be the no limit. And if the proceeds of crime involves any offense under paragraph 2 of part A of schedule offenses under narcotic drugs and psychotropic substance act 1985, rigorous imprisonment from 3 years to 10 years will be imposed, and a fine up to 5 lakhs. This 5 lakhs has been revised now. There is no limit as such now. And in addition, a tainted property shall be confiscated by the central government. So the government will also confiscate the property. And now in 2012, there is a change and amendment under section 3 of the act. Mere possession of proceeds of crime is now an offense. That means even though you have the possession of certain proceeds also, that is treated as crime, and they may arrest you also. What it means if X deposits tainted money, that means the money that has come in the wrong route in the accounts of Y, then Y also will be punished. That means even though the Y has no link, but he has allowed to have the deposits of wrong route, so Y will also be punished. And amendment is that 30 lakhs threshold limit for initiating money laundering cases for economic offences is done away. So 30 lakhs limit is done away. Even small amount also they can impose this act, and a person can be booked for laundering even 10,000 if the offence violates any of the 30 acts listed under Act. And rigorous punishment of at least 3 years and up to 7 years is the punishment, and no upper limit on fines. Earlier it used to be 5 lakhs, I have told you. Now there are no upper limits on fines. Any amount can be imposed as fine under this act. So there is an amendment in 2012 there that it adds the concept of reporting entity. That means a reporting entity means which would include the banking company, financial institutions, intermediary and post offices, etc. Reporting entity means that the CTR and STR I have told you back regarding the transactions of suspicious transactions and transactions about 10 lakhs I have told you. And Pmla 2002 levied a fine up to 5 lakhs, and amendment has removed this upper limit I have told. And it also provided for the provisional attachment and confiscation of property of any person involved in such activities. So that is there. And what is enforcement directorate? Whenever there is a money laundering aspect, then comes into picture this enforcement directorate. The enforcement directorate is specialized financial investigation agency under the Department of Revenue, Ministry of Finance, and in 1956 an enforcement unit was formed in the Department of Economic Affairs for handling this exchange control laws violations under the Act. And in 1957 this unit was renamed as Enforcement Directorate, and ED enforces the following laws. What is that? A FEMA, that is Foreign Exchange Management Act 1999, and PMLA, that is Prevention of Money Laundering Act 2002. Whenever there is a case, ED will come into play. Here you should understand that the proceeds of crime, that means what are the proceeds of crime? Whenever there is anything that is taken illegally, we have seen there are many other activities through which this income is generated through crime, then that will be called a scheduled offense. And that scheduled offense, if it is concealed or transferred, that amount is transferred, in such a case the property will be attached. That means attachment of property will be made, and that attachment can not be beyond 90 days. What shall we do within that 90 days? Means within 30 days it should be reported to the adjudicating authority. And here there will be people called assistant directors in the ED, and they will report to the adjudicating authority. In the adjudicating authority you will have one chairperson and 2 members, and for them they will be these directors or assistant directors. They will report to the adjudicating authority with a request to retain the proceeds or records or property of this money laundered amount. And the chairperson age will be 62 years, less than 62 years of age, and the term will be for a period of 5 years. It will be same for members and chairman also for the adjudicating authority. Here there will be inquiry and investigation. The enforcement officer conducts inquiry and investigation upon the accused and suspected and any other person on the basis of the information received from agencies like CBI, FIU, EOW, income tax authorities and other authorities, and they will summon under section 50 of PMLA. The enforcement officer issues summons to the persons for recording their statement and for production of the document, and any statement recorded under section 50 Act is admissible as evidence in the court. And there will also be provision for survey, search and seizure under section 1617 of PMLA. The enforcement officer, on the basis of information gathered through the inquiry and investigation and the result of summons issued, may, after being duly satisfied of the commission of offence of money laundering, may conduct a search and seizure operations also. And proceeding for retention and records on properties, original application filed under section 17.4 of PMLA before the adjudicating authority, and proceeding for confirmation and provisional attachment of properties and the original as per section 5.5 before the adjudicating authority, and proceeding for criminal prosecution complaint filed under section 545 of PMLA before the special court. These are all the procedures that are involved in the PMLA. And here if we can see the adjudicating authority, if they have the reason to believe that that offense under section 3 has been committed by a person, a 30 days notice will be issued, and they have to inform what is the source of their income, whether the source of their income is white money or black money. And financial institutions also have certain obligations to maintain certain records up to a period of 10 years. Like financial institutions includes banks, post offices, etc. And from the date of cessation of the transactions, that means if the transaction happens today, some about 10 lakhs, it should be kept in record up to 10 years. That is the obligation for the bank or post office. And if they don't comply this, if the financial institutions, they don't comply with their information, and if at any point that ED asks for information, if they are unable to provide because of non-compliance, then a fine of 10,000 to 1 lakh will be imposed. This 10,000 to 1 lakh is important, you have to know. And the power to arrest, then the director or deputy director or assistant director can arrest the offender also in this case, and within 24 hours they will arrest and they will submit them to the judicial, they will produce before the judicial magistrate. And there is another aspect, that punishment for vexatious search, that means ill intentional search, that means actually that person is okay, but even then without any proof or record, if you go and search the other person, that is called vexatious search. That means false search, I mean to say, with the false and if anyone produces false information also whenever something is asked, and failure to give information, if you ask also he doesn't respond, in such a case, even for this vexatious search by the ED department, or the false information or failure to give information by the person whom we have asked, this ED asks, in such a case also, all the cases the fine is same, that is 2 years imprisonment and 50,000 fine will be imposed. And there is one more aspect, if the person refuses to give statement or refuses to sign any document that is required under this case, in such a case 500 to 50,000 can be imposed as fine. And all offences under this act are non-bailable and cognizable. So this is very important. All the offences are non-bail. No bail will be given under this act if a person is arrested so this is a cognizable case. And here you can see that the power to summon and production of records and give evidence as per sections 11 and 50 also. The adjudicating authority and the director have the same powers as vested in the civil court. This is important. The powers are similar to the civil court under CPC while trying a suit in respect of the following matters. What are the matters? Discovery and inspection of anything, and enforcing the attendance of any person, including any officer of bank, company or financial institution or company, and examining him on oath, and compelling the production of records, and receiving the evidence on affidavits, and issuing commissions for examination of witnesses and any other matter which may be prescribed. So all these things, they may ask you questions, they will give 1, 2 and 3, and they will ask whether these are correct, A is correct, B is correct or C is correct, like that they may ask. All such proceedings are deemed to be judicial proceedings. They are treated as judicial proceedings only. Then power of retention of property and records is also there, where any property or records have been seized and the officer concerned has the reason to believe that the property is required to be retained for adjudication. The property may be retained for a period of 3 months from the end of the month in which the property is seized. That means whenever you want a property to be retained in the possession of the ED, then they have to, if they have the reason that to believe, then they can be retained up to 3 months from the end of the month in which the property is seized. On the expiry of the above period, the property should be returned to the person from whom it is seized, unless the adjudicating authority permits retention of such property beyond the said period. So if the ED wants to retain, the director or assistant director wants to retain that property under seizure for a prolonged period other than that 3 months, then they have to request the adjudicating authority that they will retain this property for so and so reason, and then the adjudicating authority will permit. That is how it happens. And retention of property, as we have seen now, 3 months from the end of the a date at which it is seized, and a report has to be submitted in a sealed envelope to the adjudicating authority stating that we want to keep it with us, the property, until some inquiry is going on, until some inquiry goes on. And director can withhold until release of any property until appeal. There is a concept of appeal also on the adjudicating authority's decision, and that will be for a period of 45 days. Within 45 days of adjudicating authority's decision, they can go for appeal, and retention of records will be for a period of 3 months. They should keep it there. And burden of proof, that means when a person is accused of having committed the offense under the section 3, then the burden of proving the proceeds of crime or untainted property shall be on the accused. So here this is an important aspect. They may give a question like this also. Generally the burden of proof will be on the investigating authority, but in this Prevention of Money Laundering Act, that burden of proof lies on the accused, on whom that is there. They have to prove themselves that this property is from the right source and it is not from a wrong source. And appeal also, you can go for appeal after within 45 days to the appellate tribunal. There will be an appellate tribunal constituted for this purpose. And even if they don't satisfy with the appellate tribunal's order, they can go for high court within 60 days. So first initially they go for appeal on the adjudicating authority's order, and they will go to the appellate tribunal, and on these orders of the appellate tribunal they go to high court within 60 days. So this is 45 days, this is 45 days, this is 60 days. Okay. Then comes the appellate tribunal. What is the constitution? There will be a chairman with age less than 68 years of age, and 2 members will be there, similar to that of adjudicating authority. And those 2 members should be having less than age of 65 years, and the term will be for a period of 5 years. And the chairman of the appellate tribunal will generally be who has worked as a judge in the Supreme Court or High Court. And a member of the adjudicating authority will be a High Court judge or a member of Indian Legal Services. Generally, no sitting judge of Supreme Court or High Court will be allowed to act as the appellate tribunal, but one who had already worked, they can be brought in here also, and except with the consultation of CJI. This also can be done, but with the consultation of the Chief Justice of India, they can put as Supreme Court or High Court judge as the appellate tribunal chairman or member as such. So here one more point is that the appellate tribunal shall not be bound by the procedure laid down by the Code of Civil Procedure 1908, but shall be guided by the principles of natural justice. That means they will weigh more on the natural justice other than simply following the Code of Civil Procedure. They are not bound to follow the Code of Civil Procedures. They will have their own set of rules that is subject to the provisions of this Act, and the appellate tribunal shall have the powers to regulate its own procedures. One more point is that civil court has no jurisdiction on these aspects. Okay, this is all about the preventive money laundering. If you like the video, just subscribe to Career Post for more marks and higher ranking. Subscribe to Career Post. Thank you.